Pleasure to be here. We are more than happy for you to interrupt us every minute with questions, so feel free. And don't wait until the end. If there's anything we say which you don't like, don't agree with, or want some more information, please ask. For those of you who have the app downloaded on your smartphone, there are a couple of polls to take. So if you haven't downloaded the app yet, Naomi's just walked in, you should download the app, and we'll be very pleased. And we'll do the polls as we go through the talk. So, quick overview of what we're going to talk about today. Because we're talking about a foreign tax authority, so we're assuming that some of you guys will be service providers in offshore jurisdictions, some of you will be advisors in onshore jurisdictions. But if you're a service provider in an offshore jurisdiction, what should you do when you're caught up in a foreign tax investigation? In order to understand it, we need to look at the global context and the global landscape, so we'll talk about that briefly. Jim and I will then take you through the tax information exchange agreement process. How does the foreign tax authority get information in the first place through the TIEA network? What happens when you're contacted then after you've disclosed information under a TIEA request? And what we're seeing increasingly is a request for you to cooperate voluntarily with the investigation in the foreign country. A key issue and a key theme for our talk is balancing, if you are a service provider, balancing your interest of self-preservation with your duty of confidentiality to the client. One thing that's very close to my heart, and Jim's heart to you, is getting paid. You want to get paid for being involved in this investigation, and if you are instructing foreign counsel and local counsel, they want to get paid. But there's some significant anti-money laundering issues at play when you're trying to get paid and pay your advisors in a tax investigation. And finally, it's pretty good if you can stay out of prison and stay in business. Okay, so the question for the poll, for those of you who have the app downloaded, is if the IRS or any foreign tax authority came knocking on your door a year after you've given them disclosure of documents on your client, who is the taxpayer on the investigation, and asked you for voluntary cooperation, would you? So the answers, I think, in the poll will be yes, maybe, or no. Slightly different out there. So any of you who've got that, please answer the poll now. And at the end of the talk, we're going to ask that question again and see if we will make you change your mind. So, global landscape. Jim, I think you see, as we see, Jim's obviously a US Chinese advising on US side tax investigations on offshore Chinese advising on.
Hello? If you could take your seats, please.
We have some seats here, David, if you need any extra. There's an unstoppable global momentum towards automatic exchange of information. So we have the TIEA network. Obviously, FATCA and Common Reporting Standard are going to provide further information to foreign tax authorities. Something I'm seeing, and Jim, I'll ask you what your experience is, the increasing pressure from money laundering prosecutions and regulatory enforcement. One of the things that I see in the last year particularly is the global community, particularly G20 and the IMF, want to see offshore jurisdictions having more money laundering operations. They quite simply think we don't have enough. And there is an increasing political pressure being put on offshore jurisdictions to do just that, to get more statistics, more money laundering operations. Jim, do you see that in Cayman or Caribbean where you were advising? I certainly do in the European side.
Well, certainly from the U.S. perspective, after the UBS came to light, it was a bit of an eye-opener for the IRS and the Department of Justice, I think, understanding how widespread the non-compliance was by these taxpayers globally. And out of that came congressional initiatives. Everyone's familiar with FATCA now, but that was a major piece of legislation. It took a long, long time to get the regulations out, and finally when they did, the reaction initially was perhaps that wouldn't go through, but it did. And out of that sprung the intergovernmental agreements that we see worldwide, which actually causes the jurisdictions in most jurisdictions to adopt new TIEA new TIEA, new Tax Information Exchange Agreement with the U.S. It's much broader than the typical TIAs or using even the MLATs. Out of that also came implementing legislation for the local jurisdictions' laws to allow certain information to be able to be exchanged. So once that was adopted and recognized as something that the foreign jurisdictions were comfortable with, we then saw the move from the OECD and the Common Reporting Standards and the proposal to have the OECD standards in place by 2017. That's going to be a bit of an aggressive timetable. But certainly by 2018, 2019, you'll have an automatic exchange of financial information globally. So it's quite a tidal wave to watch what's happened. And it does raise significant questions with respect to that jurisdiction's role in allowing what would otherwise be confidential information. And I guess the question then becomes, is it enough to have the loosening of the local laws because of FATCA, or there's going to have to be additional loosening of those laws? The reason being is that the OECD rules themselves are different from FATCA. FATCA is designed to identify the beneficial owner of an account for tax purposes from the U.S. perspective. So if you have a structure, the idea is, well, who is the person that's supposed to be taxed within the structure? The OECD rules are much more of an anti-money laundering regime, and while they will identify the beneficial owners, they also want to know, for example, protectors of the trusts or anyone else who's an enforcer of the trust. So all of the names, all of the locales, I should say, there's just a lot more information being gathered with respect to the OECD. There's some inconsistencies in the definitions within FATCA and the IGA, and most jurisdictions also have their own implementing laws or interpretations of the IGA. And so we see differences even just in the FATCA regime, the differences in the definitions for a variety of jurisdictions. But now you layer on that another OECD set of definitions, and they don't always match. So it probably will work its way out, but it's going to take some time. But at the bottom, you're going to see just a tremendous amount of access to financial data globally. And I know from the U.S. perspective, the ability to enter into multi-jurisdictional audits, so the U.S. and the U.K. and Italy would like to partake in an IRS examination or a tax examination from those three jurisdictions, because each of them have an interest in a multinational company that is involved in generating revenue in those three jurisdictions. Plans are underway right now to commence those audits in those three jurisdictions simultaneously, which is something that wasn't done previously because the information that had to go across had to be pretty narrowly tailored. You could only share under certain circumstances. So I do think the world is changing, and I think the enforcement role and the ability to partner with other foreign jurisdictions by the U.S. authorities, I think, is something that's going to change.
I think you're quite right. The key message is information is at the fingertips of foreign tax authorities. Currently, with UK and US FATCA, for a lot of jurisdictions, they will have so much information going to them from June. So the first FATCA reporting is in June. There are a number of people out there who think that there will be what's called information overload, that the IRS, HMRC simply will not be able to deal with the amount of information they're getting on the FATCA reporting. That's just not the case. I'm sure Jimmy can talk about the IRS systems, which is the Pentagon, I understand it. The UK system has a software package called Connect, and HMRC has the ability to literally connect the dots in seconds. I was involved in a case where there was a disclosure on the Liechtenstein voluntary disclosure with HMRC. HMRC came back 24 hours later to say, you've missed something. And they were able to connect other disclosures made by other parties regarding this particular taxpayer. And a needle in a haystack, basically. And in 24 hours, they were able to find that needle in a haystack. So information is very much at their fingertips, and they're able to mine that information and assimilate it and interpret it. IRS, is that no different? So I want to give you an anecdote in terms of money laundering prosecution. So the chances of service providers being actively and intentionally involved in money laundering is pretty slim nowadays. There may be a few jurisdictions out there where that statement might be told true, but by and large, that's just not something which happens. What you will find happening more often is where you're unwittingly caught in tax evasion or some form of fraud or other criminal scheme. The most common money laundering prosecution that we're seeing at the moment, and you see this in we're advising a couple of international fiduciary businesses, is the offence of failing to disclose a suspicious transaction. The failure to disclose the offence doesn't require there to be any underlying money laundering. If, as a service provider, something hits your desk which is suspicious and you don't disclose that to police somebody who proceeds to crime or anti-money laundering legislation, that's a criminal offence. And we're seeing in a number of offshore jurisdictions that point being prosecuted. And it's a very, very easy prosecution to take, because if a reasonable man thinks that something is suspicious, you ought to have disclosed it. You didn't. That's it. There doesn't have to be any underlying money laundering. And in the case I'm advising on at the moment, there specifically isn't any underlying money laundering by the client in question, the fiduciary stand. And the fiduciary fails to disclose something which is suspicious, and they're being prosecuted. And there's a very good chance they will be convicted. And so there are easy money laundering prosecutions to take, and we're going to see that increasing time and time again. Another issue we're seeing is that the tax authorities in the offshore jurisdictions being asked now by their police forces, their financial crime units, to share with them, there's probably really been paid for this, right? To share with them any criminal TIEA requests received, because the financial crime unit of the police in these offshore jurisdictions now want to investigate in those circumstances to see if there has been any money laundering. I think that the second last comment is about tax evasion. The moral argument: tax evasion, clearly illegal; tax avoidance, illegal; legitimate tax planning, legal. Well, the moral argument is moving, the legal line is moving, and increasingly we're finding that onshore jurisdictions are legislating so that even legitimate tax mitigation planning is going to come under scrutiny. Jim, have you a view on public registered beneficial ownership? Because this is another method by which investigators are going to get information. Yes.
A question. Why do you believe that there's this drift towards more and more regulation and inquiry, and is it a legal question, a moral question, etc.? What's pushing that trend? Question number one. And question number two is, what will be the outcome of that process? What will the picture look like?
I think we look at the UK, for example, which is the biggest jurisdiction closest to my home. The Starbucks, the Googles, the Amazons with their transfer pricing, with their base erosion, profit shifting, those guys and the big four accounting practices have all been hauled up before Parliament committees, so like your Senate Judiciary Committee here. They've been hauled up before the committees in London to answer for their legitimate tax plan. Because in that case, the chairman of the Public Accounts Committee, Lady Margaret Hodge, who is a real rottweiler, she just doesn't get it. She thinks it's immoral that these big four can be advising the blue chip multinationals to pay an effective rate of tax of 2-3% on their billions and billions of dollars of revenue in the UK. And it's the same story throughout Europe. So you've got a couple of key politicians and major decision makers who are pushing it more. And the outcome? I think the outcome is we'll see what happened in the UK in the budget this year, for example, a new raft of criminal tax offences, including the criminal offence of assisting an evader. And that's where they're trying to get the big four and other tax advisors to put them into the crosshairs, and a new raft of civil penalties for people who advise clients to effectively reduce their tax bill. So the line currently is commit criminal tax fraud. The line is moving to reducing your tax bill. That's certainly the rhetoric coming out of the Parliament in the UK and in other European countries and the EU.
Well, I think the difficulty you have in some of the offshore jurisdictions is really understanding what's happening with that particular party's home tax regime. So, for example, what you're just talking about, if you had something that was set up in the trust structures, let's say, outside of the UK or outside the United States, in that jurisdiction where that trust resides and is administered, the question then becomes, well, are the parties in that foreign jurisdiction participating in your example, this planning or the part and parcel of this quote-unquote conspiracy to evade tax? It's very difficult to even understand the tax laws in your own country. But what I found is that when you move from jurisdiction to jurisdiction and you're worried about the Australian tax laws, the UK tax laws, the Italian tax laws, the US tax laws, it becomes very hard for service providers in those not home jurisdictions to even understand, and it's hard for me to even understand some of the, what is the technique that works in Australia that's a technique that does not work in the United States. And if the planning was done in a certain manner, was it done to evade taxes in the US, or was it simply just a legitimate tax planning vehicle in Australia? So it's you almost have to, at this point, figure out whether you're going to have a regulatory or compliance officer identify where everyone may have to pay taxes and get advice as to whether the structure is properly set up. Maybe it's a tax opinion, maybe it's some other discussion with the tax professionals that put it together to determine whether or not you want to continue with that particular structure. So we've certainly seen that. Secondly, on the SAR issue, on reporting of suspicious activity, we are now seeing where there's any question of whether or not the particular structure and parties who are participating in the structure are tax compliant. Even if you don't have to ask that question under foreign jurisdictional rules. But if you do ask that question and you're not getting a satisfactory answer, we're seeing SARs being out of protection, just to say, look, we filed a SAR on this, we're not sure whether this works in Australia, not sure if this works in the UK, we're not sure if this actually works in the US, so we're gonna just issue a SAR and let the local enforcement group decide whether or not they want to pick up and share or pick up and investigate.
The difficulty with doing suspicious activity reports, and we see this time and time again, the client, or client's fiduciary or service provider, does a suspicious transaction report, suspicious activity report, when they get contacted for a request by a foreign tax authority. But it's too little, too late at that stage. They've been running that structure for years. The underlying fraud, money laundering, tax evasion has been happening for years, and it's not a panacea to having been involved in that to do a SAR today. I think that's a mindset you've got to get over. Some people think we do a disclosure today, having run the structure for 5 years, we're safe. You're not. It's important to consider at the outset of the transaction what we advise clients is the due diligence and the knowing your client and knowing your customers is not just a tick box exercise. It's so important that it's substantive, because how can you tell if that tax planning is legitimate in Australia and the US? What do? Do you ask for a tax opinion? Do you get a tax opinion yourself? Can you trust the tax opinion? If the tax opinion says this is all fine provided the taxpayer reports this, do you know the taxpayer is reporting it? Do you ask for tax returns? How many clients are going to give you their tax returns every year? And if they redact them, do you know that what's being redacted is the bit that they've left out? One case we were involved with, clients got comfortable with, my fiduciary clients got comfortable with the American clients' tax reporting, because one of the 3 structures they administered was a fair trust, a fair nominee, and they were filing FBARs and the right forms for that. The US taxpayer was filing FBARs. They weren't filing FBARs or anything else for the other 2 structures. And my clients assumed they were. My clients assumed that because the client was open with the tax office in the States, the IRS, about his interest in fair trustee, that he must have been open about the other 2 companies. And he wasn't. And that's an investigation that's ongoing today. Very briefly, if you want to get into the TIEA's public register of beneficial ownerships, I could get on a soapbox for an hour, I think you too, Jim. On Thursday, the UK is going to general election. And Ed Miliband, the leader of the opposition, is insisting that if he gets elected, and he's already told his young children that daddy and mummy will be moving to a new house soon, so he's pretty confident that he's going to get elected. I call that counting your chickens before the hatch. He's told the offshore jurisdictions with the British connections, so the crown dependencies of the overseas territories. In February, he wrote a letter to the chief ministers of those countries to say, you've got 6 months from my party getting into government to bring in a public register of beneficiaries. 6 months. If you don't, I will tell the OECD to put you on the blacklist. Now, two interesting things, apart from the fact that it's fundamentally misconceived and a public register would serve no useful purpose. Well, I don't say that in front of David because he thinks it will. Two things. Firstly, he didn't actually send that letter to the chief ministers. He put it in the Guardian newspaper, and the chief ministers never received it. I was with the Minister for Finance of Gibraltar last month, and he told me that the Gibraltar chief minister didn't get it, still hasn't got it, 3 months later. Our chief minister in the Isle of Man still hasn't had the letter. So they read the letter from Ed Miliband in the press. So some of them have taken to responding to him in the press, including saying, "Dear Ed, I'm very disappointed, I still haven't had this original letter." But the second thing is, the OECD has come out to say, we will not blacklist these people. This is not an international standard, and we don't require it. The EU doesn't require it. So there's a number of countries who are acting unilaterally to require public registers of beneficial ownership. I just think it's misconceived.
Well, the second component of that is the idea behind FATCA was to get to the beneficial owner, right? Drill down through every entity to find out, you need somebody with legs, right? You need to find a human being behind the structure. And who was the owner, was the beneficial owner. One of the common constructs that many jurisdictions have is the ability to do eligible introducers rather than to rely on an eligible introducer form rather than to have to dig all the way down. So for example, if I have a client, a financial service provider, and I have a client, and my client would like to go, I make the introduction to another service provider, I can say that I've collected all the data, and I'll sign off and say that I've collected the data. I know who the beneficial owner is, but I'm not going to share that with the other service provider. And under the laws, in certain jurisdictions, you're allowed to rely on that. And therefore, the second service provider says, fine, I don't need to gather everything that I need to gather because the first service provider has collected it. So if you think about the public, why is that? First of all, many times the first service provider understands who the beneficial owner is, but if you think about the structure, sometimes they're very sensitive, and sometimes there are names associated with certain amounts of money or property is something that could be very dangerous in their own home country. So there are legitimate reasons to ensure that the anonymity of that particular party to the second service provider or third service provider maybe makes sense. And so to put it in a public register, I think would be I think in certain circumstances might create a danger because those structures are sometimes set up for legitimate real concerns over safety.
The Chief Minister of Gibraltar has coined the phrase kidnapper's charter. He thinks a public register of beneficial ownership is simply a kidnapper's charter. Something I quite like. Okay, so you're in a foreign jurisdiction, you're offshore. You receive a tax information request. The TIEA process is increasing. The use of TIEA is increasing significantly year in, year out. And as Jim said earlier, it's a much easier process than an NLAT or Criminal Justice Act application. It's simple and cheap. And the return on investment for effectively a letter is huge. So all that's required is the foreign tax authority sends a letter to Ireland, Cayman tax authority. They get it, they check it against the safeguards in the TIEA, and they issue the letter to the local service provider. That's it. It's nothing more formal or complicated than that. And generally, we looked at some statistics in Sweden and Australia in the last 2 years. In the last 2 years, every Swedish letter sent on a TIEA has recovered €1 million to €1.2 million. So for literally penning one letter, okay, there's an element of tax investigation involved too, but it is a cheap and easy administrative process. The Australians are recovering about $2 million Australian dollars per TIEA letter that they issue. And that's their average figures, but it just shows it's a simple, easy process, and it's on the up. The most common TIEA is served by India. India is the most prolific user of TIEAs globally at the moment. Not the IRS, not the UK. French and Swedish are also high users of them too. Jim, you get the TIEA. Before you sit down and look at the specific wording, perhaps you want to decide if you challenge the TIEA. And I know you've had a couple came recently. So short of going to court to challenge a TIA request, how would you look at challenging?
So the first thing you want to look at is whether this is coming out of a civil or perhaps a potentially criminal proceeding. And that, you know, if you can find out where it's coming from, it's fine. In most jurisdictions, it's difficult to get behind the actual request. Most offices that deal with the request for TIA information do not share the original request. And so you're not quite sure ever whether you have something that is just cut and pasted and said, yes, please comply, or whether it's been modified or not. So the first thing you need to do is you really need to look at the content of the request and get with your client to make sure that you can ascertain where this may be arising from and whether you think there's any criminal exposure. What we found in the last few years is the use of the TIA request after correspondent bank John Doe summonses have been issued in the United States. And so a lot of times we're able to figure out where the TIA came from if we don't have a counterparty at the U.S. government that we're working with. There's simply a broad swath TIA request is to see if the correspondent banking relationships were served in the John Doe summonses. Because in the United States, if you're dealing with U.S. dollars in your foreign jurisdiction, you gotta have, you know, a branch in the United States, you're going to be using a correspondent bank in order to, deal in dollars. And so the correspondent bank in the United States is a place where there is jurisdiction, and there is jurisdiction to issue John Doe summonses, which is basically a request for a certain group of accounts that deal with a certain type of transaction, with a dollar amount, whatever it might be. From that, there is generally a TIA brought, because that's a good data source. It provides dates, it provides amounts, it provides, a transaction history that is tailored fairly closely to what you need to make a TIA request. So we typically start looking at the request, and if it looks like it might have come out of the John Doe summons, we contact the correspondent banking relationship to say, listen, have you been served with the John Doe summons, and try to get as much information as we can as to what the investigation might be. Something on the TIAs that I just want to mention is that because of the intergovernmental agreements, the IGAs that are enacted along with FATCA, the TIAs now are much broader than they used to be. The TIA requests were pretty tight across jurisdictions because in the U.S., the requirements were pretty tight as to what you had to request. There's the set of power factors, and they had to be fairly narrowly tailored in order to get the information from the other jurisdiction. You had to be identify the parties. You couldn't do a broad basic class typically. Today, though, because the TIAs have been rewritten, they allow for a broader categorization of requests. And so you can ask for documents associated with parties who may or may not have been involved in a certain type of structure or a certain type of transaction. The range of years is getting larger and larger, because we're going back 10, 15 years of data associated with a particular party. So it's easier, you're correct, I think it's easier for the TIAs to be issued. The John Doe summonses and correspondent banking relationships have been authorized. I don't know if any that have been denied. And so the ability to then go ask. So it's important to try to figure out what's going on for your client and try to figure out whether this is something criminal. And the local laws then come into play. So if you have a situation where you're under compliance by an office that deals with TIAs in a foreign jurisdiction, they will tell their constituents, this is how I would like you to comply. Now, there are often administrative vehicles to challenge the TIA in the foreign jurisdiction. We partner with law firms across the globe because they're familiar with how to proceed and what the proceedings might be. Some are simply administrative. Others require administrative due process first before you would go to a court. Others have processes where the third parties can come in if they're aware of it. Typically they're not, but they can come in and challenge. And we've seen TIA challenges post facto because the TIA offices often require you to turn over data. The data gets turned over to the foreign jurisdiction. was impacted then said, well, how did you get this information? And they turn around and they bring their own private action. And I know you're familiar with some of those cases.
That's a good segue into challenging. So, what Jim says, we look at the form of the TIEA very carefully. We read it absolutely word by word because foreign tax authorities often use loose language. Generally, when the TIEA is issued, it then has force of law in your own jurisdiction, so you have to comply with it, and to comply with it is not a breach of confidentiality to your client. However, if you over-comply, if you give something that actually on a clear and concise reading of the TIEA wasn't asked for, but you read it quickly and thought it was asked for, you've not got the benefit of the breach of confidentiality defense to your client. So read it very carefully. Jim and I, we often look at it and decide whether to go back to the tax office and challenge it administratively to say there's a problem with this. And we've had in the Isle of Man a number of them challenged administratively, whereby they accepted that either they shouldn't have been issued in the first place because they didn't comply with the TIEA, or that the information requested was too broad or not received relevant. There's been a number of offshore cases where those challenges then went to court. None of the Isle of Man so far, but there's been two in Jersey, one in Cayman, one in BPR, and one in Bermuda. The one that Jim just mentioned was the Cayman case of NH Investments, and that was a 2013 case. And Australian Tax Authority requested information on two Cayman companies. The Cayman Tax Authority issued the TIEA. The Australian Tax Authority also asked for permission to hand over that information to HMRC in the UK. The Cayman Tax Authority granted that permission. After the information was disclosed to the Australians, the companies in question went to court in Cayman and challenged the judicial review of the decision to issue a TIEA request in the first place. And the court found that the Cayman Tax Authority overstepped the mark. They didn't comply with the Cayman TIEA law. They should have gone to court for directions as to whether or not to consent to passing on the information from Australia to the UK. And the Cayman court said, right, Cayman Tax Authority, you've got a right to the Australians and ask for all the information back. Also ask them to confirm they haven't passed the information to HMRC. Cayman Tax Authority did that. The Australian Federal Court then dealt with a challenge to the proceedings because this information has been used in criminal tax proceedings in Australia. The Australian Federal Court said, no, we're keeping it. And by the way, you can send it off to HMRC. The Cayman court decision is a domestic matter for them. So even though the TIEA has safeguards in place that information should be confidential and not passed around the world, and you've got clear examples of foreign tax authorities just flagging that, ignoring the provisions of the TIEA and working together to share information in breach of the TIEA. The Bermudan Court of Appeal found that tax requests should be disclosed to the Bermudan companies. That was the Minister of Finance and Bunge Limited. And Jim, you mentioned some countries don't give you the original tax request that the IRS, in this case, this is Argentina issued to Bermuda. The Bermuda Court of Appeal said the taxpayer in Bermuda is entitled to see the original request from the foreign tax authority, so as to determine whether or not it is capable of challenge. In the Isle of Man, we haven't had that issue arise yet, but I know from doing all my TIEAs in Montana, our tax office simply copies and pastes the foreign request into a letter. They don't amend it, they don't improve on the language, they don't try to remove any ambiguity. So in Bermuda, you have the right to ask that information. I haven't seen that case being upheld in any other offshore jurisdictions yet, but it's an argument to raise. Jersey case, this is probably one of the more interesting ones too. And there were two Jersey cases challenging TIEAs. One successfully, the APEF management case. That was a 2013 case too. It involved the overzealous French tax authorities asking for information on the Jersey Limited Partnership. They suspected a taxpayer in France sold his company and put the shares at an undervalue into the Jersey structure. And so they asked for full disclosure on that Jersey structure. As it happens, the French taxpayer was the CEO of that company and wasn't the shareholder. He was a minor shareholder of that company. And the few shares he did have in that company were sold at value to a new holding company. So the tax authority in France just got it wrong. The Jersey court said, on the face of it, this is wrong. This shouldn't have been granted because the tax authority in France had a supposition, it's effectively on a fishing expedition, and they overturn rules like that. So there are times when you can look to challenge a TIEA, and just consider carefully that if you challenge a TIEA, there's an argument that the Foreign Tax Authority, if you lose, will find you to be uncooperative, and you may not see the same level of flexibility and understanding from them in any investigation. Date range, I know Jim, you mentioned that briefly. Most countries, most countries' TIEAs say that a criminal tax investigation can be retrospective, so you mentioned going back 10, 15 years. If it's a criminal tax investigation, most of the TIEAs now around the world say that the information can be requested from the year dot, from whenever. If it's a civil investigation, the information can only be requested for a taxable period from the date the TIEA came into force onwards. And often, therefore, we see quasi-civil investigations morphing into criminal ones, so the Foreign Tax Authority can get a lot more information. And that's often a ground for challenge, but it's not actually truly a criminal investigation. And Foreign Counsel, I might know my stuff about the Isle of Man and other offshore jurisdictions. I don't know anything about UK or US tax. You need to get Foreign Counsel advising when you get a TIEA in your view, because you don't know the true context. So you've provided information to a Foreign Tax Authority under a TIEA, and a year later, that tax authority comes out of the blue. So the most common one I see is the IRS emailing my clients directly saying, remember me, you very kindly gave us documents last year. It was very helpful, very useful for investigation. We're in the Isle of Man next week, we'd like to talk to you. I know you've seen that too, Jim, and I talk about this is really bypassing due process. But there's a process in the Caymans that you come across in terms of asking for foreign assistance.
Every jurisdiction has set a sort of a protocol for the ability for the U.S. authorities to approach a citizen of a foreign jurisdiction. And in the U.S., there's an Office of International Affairs, and there are individuals within that office who know the rules with respect to each of the jurisdictions. And so if there is an outreach, obviously the protocols for that particular jurisdiction have to be met. There are jurisdictions where you are required to go through and get a court order to allow any law enforcement from the U.S. to come, or an investigatory branch of the U.S. government to come and to conduct an interview. Some jurisdictions are so strict that any questioning has to be previewed, and it's rather onerous to get there. Other jurisdictions are less, have less rules, less strict, and they allow U.S. authorities to come on site if the person who's going to be interviewed or the entity is allowing employees to interview in a cooperative mode. And so if they decide that they want to allow that, they can do it. And so in that instance, we typically have U.S. counsel represent the individuals individually for their own interests. We have U.S. counsel that is advising the entity. And there's also local counsel that has to get involved because the statements that are being made, sometimes the question that comes up deals with confidential information. I think what I have found is that U.S. authorities are very respectful of the fact that there are confidentiality rules. They do carry civil and sometimes criminal sanctions. And so they're mindful of that, and at least the investigations that I've been involved in, they will understand that and they will adhere to that. But it's very important for that person who's being interviewed, if you allow the interview to go through, to make sure that they have counsel, U.S. counsel, and also Cayman or any of the Caribbean entities, even in IMN, I would imagine that you would want to be there to make sure that any of your particular rules, because sometimes confidentiality rules are not as clear to the individual who's being interviewed, that they don't violate their own rules of confidentiality.
I think you're quite right. In the TIEA, there's a mechanism for the Foreign Tax Authority to ask for permission to come and examine you and interview you in the offshore jurisdiction. And that, again, is just a simple letter process. IRS will write to Cayman Island Tax Authority and ask for permission. That is a process by which government to government will sort that out. And it doesn't give you a defense to a client confidentiality claim, because that's a voluntary process. Our view, generally, and increasingly, because of how hostile foreign tax authorities are becoming, our view is that voluntary cooperation should be something that you consider very, very carefully. the default position to say we're not compelled to meet the IRS, we're not compelled to answer their questions, and if we do, we might breach confidentiality, therefore we will say no, is increasingly a dangerous position to adopt, because if they're contacting you out of the blue like this, the chances are they're treating you as a witness, and that's a nice place to be, because you don't want to be the target or one of the targets of investigation. You can very quickly morph into a co-conspirator. The more uncooperative you are, even if your reasons for not cooperating are valid and legal, the more uncooperative you are, the more likely that the foreign tax authority will treat you as a target and as a co-conspirator. One of the ways we deal with client confidentiality is to write to the taxpayers, to write to the underlying client, so we and to say we've been asked to voluntarily submit to an interview, talk about your structures. Can you please confirm you don't object? So you don't ask for consent, you just confirm you don't object. And in the last two cases I was involved with, the US counsel for the taxpayer, the US taxpayer, advised him not to object. That's correct, yeah. Because he took the view to object to that would be seen as uncooperative, obviously, but possibly obstruction, possible criminal tax criminal offence. I know Jimmy had a different view of that, different US advisors had different thoughts. But we got the client, underlying client, to write back to say, I don't object. It wasn't the same as my consent, but we took a commercial view on behalf of our clients, the producers in our plan, that they were safe to proceed to voluntary cooperation. Or that client wouldn't be able to sue for breach of confidentiality because they had the opportunity to object and didn't. They didn't use the word consent, but it was an effective consent. You have a slightly different view.
Well, I think I'd just like to address it. You're discussing a situation where the party in question is on the witness side of the ledger. If you're not on the witness side of the ledger, if you're targeting an investigation and you would like to cooperate in order to either have this investigation go away or to resolve the situation, cooperation is viewed very favorably by authorities. So early cooperation, and in the right instances, properly advised, that's the way you want to proceed and to resolve the issue. These confidentiality was actually becoming a hindrance because, well, if you were in the United States and cooperating, you would meet as many times as you needed to meet, you would provide as many documents as you can, you would tell the full story as much as you could, you point to other parties, perhaps, who were involved in the structure that were more culpable than you, and therefore you're trying to get the best result that you can, using all the means and all the facts and all the documents. If you're trying to take that construct and put it into a jurisdiction where you're not allowed to talk, where you're not allowed to identify who else is in the structure, where you're not, because of confidentiality. So, I could get a consenting party and there may be 5 people involved in the structure. I'm not allowed to talk about the other 4. I may not be able to even talk about the parties who put the structure together if there's an agency relationship between the other 4 parties and that person who put the structure together. So it makes it, and I can't turn over documents of other transactions that I may be aware of or talk about them in any specificity. So it becomes very difficult to take this cooperative mode and the idea that you're going to, assist in whatever the investigation is pursuing in order to, lessen your outcome. It becomes almost impossible when you're stuck against, somebody's confidentiality.
Let's think of the most difficult case. Your approach, whether it's here or any jurisdiction, to voluntarily turn information. Even if we don't complicate it, Jim, with the fact that there may be more than one client, let's use for one party that is, say, 5 owners to an entity. Let's just say there's a single owner to that entity. And you're an advisor, or maybe even an officer or a director of the company, but you're asked to voluntarily give information. You could take the approach of asking a principal, do you object to my turning over this information? Let's say you get either silence or an objection from that party. And let's make it even more interesting. You get an objection from that party. What do you do then? What do you do then?
There's two options. One, you take a commercial risk that you are going to cooperate voluntarily, notwithstanding that objection, because you don't think that any court in your jurisdiction would compensate in damages for a breach of confidentiality case, a tax dodger. Of course, you don't know that he's a tax dodger, he could be innocent, so it's a big risk to take. The alternative approach is to then go back to the foreign tax authority and say, we tried, we really tried. Here's the email exchange, here's the communications with the client. He objects. We have duties of confidentiality which we must comply with. There's an easy method for you to get this information, another TIEA, or and you can even insist on the questions you ask in the next TIEA, or a Criminal Justice Act or MLAP application to be interviewed in court under oath in your home jurisdiction. So a lot of offshore jurisdictions will have those mechanisms in place. You want to be seen to be cooperative, and if you can't help and you don't want to take the risk of breaching confidentiality, then you need to explain to the foreign tax authority that you tried. And you're sorry, but there's a different way we can help you, but you've got to go through due process in our jurisdiction. So we're compelled to answer your questions. It's as simple as that.
No, the only thing I would mention, I'm sorry.
Yeah. What happens if there are several jurisdictions involved? I give you an example that I live. We are a US company having a server in Cayman Islands where a bank of the Isle of Man would touch with confidential client information. How do we behave if the IRS in the United States asked us to give information of what is on that server in Cayman Islands?
And you're in the Cayman Islands, or are you in the States?
The company is in the States.
Okay. We have that exact case in the Isle of Man. So in that case, it was an Irish head office being forced by the Irish tax authority to disclose the server information of the Isle of Man subsidiary. So exactly the case. And the head office told the subsidiary, the bank in the Isle of Man, bank in the Cayman Islands in their case, turned over that information to the Irish tax authorities. We went to court in Isle of Man to object to that instruction. The Irish bank said, we're the shareholder. We are the sole shareholder of this Isle of Man subsidiary bank. We're telling you, we're giving you an instruction to do this. And our view was that that was an instruction for improper purpose. It breached Isle of Man banking confidentiality. And the court looked and said, well, you can't force this person to do this. You were able to stop that. But you require the offshore jurisdiction to be willing to stand up to, in that case, a foreign tax company. I'm not sure what the rules in Cayman would have, but Cayman have much more stringent confidentiality rules than we do in the Isle of Man, so I imagine it would be a similar situation. But then you've got to look at the people in the US, in that case, who are risking contempt of the court, who are risking criminal sanction, and they're going to put the subsidiary under massive pressure to do this, and it's not a nice place to be. And we've seen that with clients. But you've got to respect the law, the confidentiality of the jurisdiction where the information is based.
The other thing that we have, if the question relates to a U.S. person and their records, we have a couple of different scenarios. First, if it's their own personal records and it was covered in a sort of in the financial realm, our Bank Secrecy Act in the United States requires the U.S. person to maintain yearly all of their financial affairs, even if those financial affairs are outside of the United States. So the documents, the statements, bank statements, investment statements, if they're involved in the trust and they're a beneficial owner of the trust, any activity between them and the trust are required to be turned over on request. And therefore, there is no protections. In the U.S. we have protections for the act of producing records that would be incriminating, and we can ask for immunity because you can ask the government to grant immunity over the act of producing those records because you're not required to implicate yourself. However, there were 5 U.S. Circuit Court opinions over the last 2 years that determined that anything that came under the Bank Secrecy Act in the United States, any record that would be covered, is not subject to the act of reduction of privilege, nor would we be granted immunity. So one way around that is for the U.S. authorities simply to ask the individual if they know the individual is to turn over your records and let's have your bank records, etc. Because there's no ability to claim that you have some type of privilege over if you're challenging the turning over of records in a foreign jurisdiction, so you're telling a third party, do not turn over my records. I want to challenge this administratively and through the courts. There's a requirement in the U.S. to notify the investigatory Department of Justice, basically, to say, I am challenging the ability of that third-party service provider to turn over my records. It may not be my records, right? It may be associated with what I'm doing. It might be a trust company's records. It might be somebody else's records, but it involves my conduct. If you're going to challenge that in an administrative proceeding in the U.S., you're required to make notification. Failure to make that notification is itself a criminal offense. So really, the ability to challenge anymore, if it's your own records, is very, very difficult to do, because either you're going to be ordered by a court to go get those records and produce them because they're under the Bank Secrecy Act. If they're in the hands of the third party, they are third-party records, not technically yours, but you're challenging the release of those records, you need to make a notification to the Department of Justice. And so it's not, it's pretty hard to make those challenges. However, if it's just a TIEA request and it's a civil proceeding, that's something different. And so there you can say, well, as your case, look, I would like you to just follow the rules of the local jurisdiction. If TIEA tells you to turn it over, if the local TIEA office tells you to turn it over, do it. If they say no, then don't. I want you to uphold whatever your laws are. I don't know that that necessarily caused concern, because you're simply saying, whatever is required under the law, I will turn over. And if it's not directed at me personally, it's not a criminal proceeding, then maybe the local jurisdiction rules on confidentiality are sufficient. And you rely on that third-party service provider to do what they have to do with their own TIEA offices and either do it negotiate it through administrative means or to the court.
We're nearly done. Just a couple more points. And then it's cocktail reception time on the road. Because David March is speaking next door, they're going to be another hour or so. So we'll have the cocktails all to ourselves. Do they know the answers already? Frequently, the questions you're being asked. So you're now in an interview situation. You're sitting down, you agree to do it, you square the circle about client confidentiality, and they come to your jurisdiction. There will be, inevitably, there will be an IRS agent, the guy investigating it, and the attaché from the nearby embassy, or from the regional embassy. And they will ask you lots of questions, they will have all your TIEA documents, but you suddenly realize they were referring to documents we didn't turn over from the TIEA. They didn't ask for these documents, so they were outside the date range, they weren't relevant. And they know a lot more than just the documents you give them. And bear in mind, because TIEAs are so easy, the chances are they send TIEA notes to you, to the bank, to investment managers, to anybody else in your jurisdiction and every other relevant offshore jurisdiction who is somehow linked to this client structure. They've probably done a subpoena, it's a criminal matter, they've probably done a subpoena of the email server of the client in the States, which is something we've seen a lot. So they've got all the emails between that client and you, even though you didn't give them to them, because they might have asked for them. So the chances are they already know a lot of the answers, and they're just coming to you to verify these. It's another source of verify. I speak at conferences in the Isle of Gibraltar with IRS agents, and keep your friends closer and me closer, so we've become quite friendly. And they say, time and time again, they usually have the information already. They've got it from multiple sources. They're just verifying. They're also wanting to check your bona fides. Were you an enabler here? Are you trying to hide in this client if you don't answer these questions truthfully and honestly, in a transparent way? If you're plainly trying to wriggle out of something that's in black and white, if you're portraying the smoking gun as something other than a smoking gun, then they're more likely to consider you a target on a co-conspirator. So bear in mind when you're answering questions in that situation that they probably know the answers already, and they've joined the dots pretty well. Meeting, the last few we've done, they all wanted to come to the Isle of Man because they like to travel, and there was a budget for it, and the IRS budgets are severely constrained this year. Of course, it's better to meet in your jurisdiction, but I've had clients who have flown out to the US to meet the Department of Justice and the IRS, and of course a key concern with Patriot Act issues is my client who's cooperating voluntarily going to get arrested when he lands in Dulles Airport. Am I going to get arrested when I land in Dulles Airport? And one of the things that we get is Queen for Day letter or proffer letter. So the US attorney can get you a limited immunity letter. Jim, you know a lot more about this than I received them, and even though I was in counsel, I wasn't the witness. My clients have received them. And it gives you a little bit of comfort. You know, you can land in the US and not get arrested. And what you say during the voluntary interview process will not be used against you. So it's not blanket immunity from any criminal sanction, but it's better than nothing. I think that's another ground for in favour of cooperating.
There are safe passage letters that you can request, which would allow you to come in and out of the United States and not be stopped. So those safe passage letters themselves is the travel record that gets you in and out. And then as far as what you negotiate with respect to that day's proceeding will come under the letter that you have directly with those who are asking questions.
Meeting the DOJ on Pennsylvania Avenue is quite can be quite a scary process for your client. So the last one I took my client out to Harry's Bar, it was a cop bar in DC, and I got him drunk right before the interview just to put his mind at ease. So he was very grateful to me the next morning when he woke up with a hangover. He had other things to worry about. He was worrying about his hangover, not the interview. So little tactics of that can sometimes work. Any final questions? For those of you who have the app, would you please go back on and answer the question, would you cooperate voluntarily? Yes, no, or maybe. And there's also a question in there, have you ever been in a foreign tax investigation meeting? Jim, any final words of wisdom? No? Okay. Well, thank you all very much, and enjoy the conference.